Hello and welcome to another episode on Law and Order on a Friday evening. This week, like every week, we have a special topic and a special guest. Innovation through patent law is the topic we are going to touch upon today, and we are also going to look into the prospects and challenges in innovation patent law in Sri Lanka. And to deal this, none other than a specialist we have got in our studios today, and that is Dr. Sampath Punchihewa. Sampath Punchihewa is from the University of Colombo Department of Commercial Law, Faculty of Law, and he is my guest today, and we're going to see how we can. Dr. Sampath, thank you very much for coming on the show. How are you today?
Thank you very much for inviting me.
Yes, thank you. Let's start with the very obvious question. What is patentability?
Yes, when we think about patentability, we have to also first pay our attention. What is an invention?
Yeah.
Invention is a solution to a specific problem in the field of technology.
Right.
And in Sri Lanka, we adopt problem solution approach.
Right.
And if that invention, if the new solution is an invention, that can be patented in Sri Lanka. And as per the Intellectual Property Act of 2003, in Sri Lanka, an invention must have novelty. It must be new. Second requirement is it must have an inventive step. In other words, it must be non-obvious. Third requirement is it must have usefulness or utility. In order to obtain a patent in Sri Lanka.
Right. Is this a scenario worldwide?
Yes, in the US it is novelty, non-obviousness and utility. And in Sri Lanka we have more looked at industrial applicability in place of utility requirement. That is novelty, inventive step and industrial applicability. But in the US it is novelty, non-obviousness and utility.
What is the practical difference of this?
Practical
to people who are not lawyers or not scientists who are looking at this.
More or less these requirements are similar. Nevertheless, as in keeping with the traditions, US have this terminology and Europe is quite Europe uses quite different terminology. We have followed the UK model, and the UK has these three requirements, trinity of conditions.
You call it trinity of conditions.
Yes.
Yeah. Now, you're saying the ingredients of registering a patent. Now, before we go into the other major areas, patent has time limitation.
Yes.
Tell me something about this time limitation and why is it that given to a time limit?
It is because the trade-off, because of the trade-off, because in patent, granting a patent for historical reason, we have to incentivize inventors. That is the primary consideration.
Right.
And on one hand, we have to protect the inventive spark of the people.
Correct.
On the other hand, the country has to balance the interest of the society and also interest of the competition. Right. There, we have to strike a balance.
Right.
On one hand, you incentivize inventions. On the other hand, you have to balance. Like if you grant a patent, that would lead to sometimes exclusive rights, and that would lead to monopolization of the market.
Right.
And in order to balance, in order to strike a balance, the government, from the state policy perspective, we need to balance. That is why you reveal the secret, and we will give you exclusive rights for 20 years. 20 years.
Worldwide is 20 years?
From the date of filing the patent application. 20 years is the lifespan, time of the duration of the patent.
Okay. Now, what happens after the 20 years?
After 20 years, it enters the public domain.
Right.
And then anybody in the world can practice it, can produce it, and can market it.
Right. Again, a contradictory question, which is just coming up from people. As a practitioner, I see this. Copyright has life plus 70 years Sri Lanka. Worldwide, copyright time limitation is more.
Yes.
Now, copyright is also for a creation, right?
Yes.
It's also part of intellectual property.
Yes.
I'm just taking this beyond
Yes.
the patent
Yes.
subject of today.
Yes.
And patent is also a creation.
Yes.
Why do you think that governments or worldwide lawmakers decided that in patent it has to be limited for this? Because even in copyright, whatever you create, it is part of economy, you make money out of that product or whatever. And for copyright, you give such a long time.
Yes.
What would be your answer? If my question is not too unanswerable.
That's true. That's
Yeah,
true.
yeah.
For historical reasons,
Yeah.
the copyright regime can be dated back to Anne's statutes in the UK, and that is copyrights protects creativity, invention. Patent law protects inventiveness. Two different things. And creativity, for historical reasons, creativity has to be rewarded by granting exclusive rights on the expression. And that may be the reason why, and I would say that for both patents and copyright law, the overarching objective is to incentivize. And it is for historical reasons, copyrights was granted a longer time because it started from in Europe. It was just the authors and writers gave the impetus to industrial revolution. And after that, we of course had patent law. And patent law, and in patent law, the exclusive rights, and I think there is a very crucial trade-off, balance to be struck.
Right. Now, in securing a patent in Sri Lanka, are there any stumbling blocks? What are those stumbling blocks for inventors?
Yes. Frankly speaking, before I come into this talk, I looked at the international innovation index. For example, the global innovation index. Sri Lanka is not doing well in that because Sri Lanka has secured only 90th place, whereas the most innovative countries securing the topmost places, spots. So we have not done well, and there is a shortage of homegrown creativity in this country, and Sri Lankan inventors. Most of the inventions in Sri Lanka emanating from SMEs and universities.
Right.
And these inventions are not reaching the very high threshold of patentability. For example, inventiveness.
Yes.
For example, if a student from Anuradhapura invents a new machine or new garbage disposal mechanism, we have the problem of garbage in this country, and he or she may find that it is difficult to secure a patent because we do ask, the National Intellectual Property Office would require you to fulfill these three conditions. Of these three conditions, the non-obviousness or the inventive step requirement becomes rather challenging.
Exactly.
Because why?
Yeah.
The simple reason, we are at the initial rung of the technological ladder.
Right.
Because the technology that we have is not that great because we have not benefited from the technology transfer, even though we have the TRIPS agreements and other things. But policies in the all in all, the policies of the successive governments might have not promoted the technological landscape. Like we have not made good strides in the innovation landscape. I would say that, and that is why our inventors are struggling to. Now, if you see viewed through the lens of the statistics, last year, 2016. This is from the National Intellectual Property website statistics, that Sri Lanka has filed 278 patent applications. Of these, only 41 patents were granted. Okay. There's a huge mismatch.
Okay. Now you said the most difficult point that people face in registering is this justifying inventiveness. Am I correct? What is the word?
Novelty. Press requirement is novelty. But novelty can be satisfied somehow or the other.
Okay.
But because that is, novelty means your invention should not have been disclosed anywhere in the world. But you might find something new. But second requirement is very challenging. Why? Then you have to prove that your invention is significantly contributing towards the advancement of technology.
Okay, now that is the problem. No? Now that is one of the three elements under the law of Sri Lanka, right? Now, what is the solution?
Of
Okay,
course,
let me rephrase that question. Not what is the solution.
Yeah.
How do we get about, now in US, for example, I think they file about 100,000 patents.
Yes.
In Japan, if you look at the patent law, is the most developed.
Robust.
Right?
Robust.
Yeah. And what are the solutions they have found to solve this?
Excellent question that you put across. Because in Japan, if you take the case study of Japan, Japan at the very initial stage of their stages of their economic development, technological development, I'm talking way back in 1900th century. They started with small patent system. They had the standard patent system, but in addition to that, they had another layer of protection called utility patents, small patents, and that is how the requirements are not that robust, that demanding in order to obtain a utility or small patent. And Japan tried with this model. So was Korea, South Korea. South Korea tried this model. And many other countries had successful stories started with small way, incremental way with this second tier, like second level patents, in addition to this general patent law, the normal patent law of the country.
Right. So my question again, I'm putting it to you, because you are academic, you have studied this, and you have even written
I have published my book as well.
What is the solution you will bring to amend? Because as you say, there are so many people, young students, all that doing patents, doing inventions, and they have no protection, and it's rather unfair. Law has to provide that. Where do you want the amendment?
Yes, Chanakya, you are absolutely right. Sri Lanka, the nation has been a very creative, very innovative nation. If you see the wonders, Sigiriya, Parakrama Samudra, all these inventions in the times of the ancient kings, we have been a very creative nation. However, what has happened now? We have not scratched, we have not explored the real potential of the inventive people of this country.
So where do you want the law to amend?
We need to start afresh. That is, why don't we amend the Intellectual Property Act in order to accommodate small patents with lesser requirements.
So it's a new regime.
There you don't have to look at the most difficult part of that requirement is the inventive step. The inventive step is the most challenging to our inventors, because most of, I found out from the National Intellectual Property Office, most of these inventions are new, but Chanakya, they are not non-obvious. They are not having adequate inventive step.
That is where they lack. That's where they get rejected.
That is where.
So you are suggesting, what is the word you use?
Utility patent or small patent or second tier patent. It can be named as anything like small patents.
Small patent.
Or utility
recognition
patent.
is the same.
Yes,
but which country does this?
South Korea has, Japan has, Malaysia has, Singapore, not Singapore, Thailand has.
US has?
No, US did not have. That is why, maybe UK and US did not have, and we have shaped our legal system
always
by
looking at only one country.
Living through the experience of the colonial
masters. 150 years brainwashing issue we have to get rid of. Now, what is the difference between the small patent or whatever you want to call it in these successful countries and the normal patent? Except for that
standard patents. Standard patent is for the high technological advances, right? But small patent is to start with small way, and you can relax the inventive step requirement, but you can also look at local novelty within the country. But when we look at the standard patent, novelty requirement is universal. Anywhere in the world, the invention must not have been disclosed to the public. But you can relax that, because the TRIPS agreement itself allows countries to tailor the requirements of small patents suited to your needs.
Now, one product I will bring in, computer programs, the algorithms. Is it a patentable thing or is it not? I'll just tell you an example which I know. In the United States, still about a couple of years ago, when the Supreme Court said, because there's a copyright registration regime, go and register your computer programs in Copyright Office. Don't go to the USPTO.
Yes.
What is the status here?
Very appropriate question, and we need to. I think
Again,
it is worth of another program, because the IP Act has specifically mentioned the protection of software under copyright regime.
Yes.
Nevertheless, patent chapter has not excluded the patentability other than business method patents.
Business method patent. What is a business method patent?
Business method, the way how you do business, and it is operated by software.
Right.
And business method patents, method of doing business will not be protected. But what about the other software inventions? Software related inventions, I would argue, may be permitted to be protected by patent regime, but that question.
Because especially we don't have a copyright registration regime.
No, we as soon as you finish developing your software, it is protected by copyright.
But we don't have a registration regime. If there's an issue, we
don't have a copyright registration system, but we can think of.
Yeah, but the thing is, it's always a problem. You have to go to court and a big battle, and people don't want to, businesses don't want to get involved in that. If there's a registration, other people will be less, deterrent effect. Other people will not try to copy. Am I correct? That's why they are in other countries.
Absolutely, but as with the Berne Convention, copyright must not necessarily be registered.
Then why is US having that?
Because it's a complementary. And when you have a case, then if you win the case, the other party, the losing party, if you have copyright, you can claim the litigation cost, and it is an advantage. It's a complementary. It's a bonus for you.
Okay. Now the patentability, your book, which you wrote for, this is your thesis, Promoting Second-Tier Protect Regime for Innovation of Small and Medium Enterprise in South Asia. You explain basically what's in this book. And the challenges Sri Lanka faces. Are these the only things that you mention? Is my one question. And the other question is that what are the things that people, is there any things that you cannot patent, although you may invent?
That is going to the question of patent eligibility. Eligibility. Certain inventions are excluded from patent protection. If you examine section 62, subsection 3, Sri Lankan law has excluded, the patent regime has excluded patent ineligible subjects.
What are those subjects?
For example, naturally occurring, if I read it, methods for doing business, animal, plants, human being cannot be patented in Sri Lanka. And the methods of treating patients, you can patent the products, but the way that you operate, a patient cannot be patented.
Since you studied this deeply and you're academic as well, let me ask you a little bit of a furthering question. Is the things that are included, obviously what we have excluded in our act, probably excluded in world conventions, we are right. Am I correct? Is this reasonable? Now, example is business. What is the
business method?
Business method. Now, I create a business method to do some business. So that is my creation. Right? And that can. Why is that? It's excluded. Is it reasonable?
Probably, I would say, because there is a protection given or accorded in the copyright regime very specifically. Maybe the second reason is the Sri Lanka, being a developing country, might have thought that we have given. The other one is that sometimes it may be more protection would deter downstream innovations. Like if you have too much of protection, that would also undermine the delicate balance between the individual interest as opposed to the interests of the society.
Okay. What are the amendments you, as an intellectual property teacher, person who lectures, what are the amendments you would want to have in our current intellectual property regime, the Act?
The IP Act, I would suggest that Sri Lankan IP Act should introduce, I would say foresee, the registration system, maybe not mandatory system, but it can be optional. That would can get rid of the problem that you raise. The second one is we can also think about the introducing small patent system to cater to the needs of the small inventors, school children, maybe some like basic simple inventions, because they may not be able to satisfy the heightened inventive step requirement.
But still it is a creation. It's
you,
valuable.
You find
invention.
something new.
Yeah.
But because you are not fulfilling the preconditions, three preconditions, you may not be getting a patent right. You may not be able to secure a patent right. Nevertheless, you should be rewarded for your creation, something new. You have done something new.
Now, apart from that, when you are looking at the way forward, because like you say, Sri Lankans have a lot of way of inventing stuff and trademarks. Is there any international convention, as you studied in Munich and all that we still have to look into and be signatories to strengthen our laws and to strengthen international cooperation? Yeah,
true. Now, Sri Lanka has, I think, ratified the Marrakesh Treaty.
Yes.
And then I think the process is now underway to amend the IP Act in line with the international obligation and also Madrid Agreement.
Yes.
Madrid Agreement.
We are on the way of Madrid exercise.
Yeah, we have already, I think we have already deposited our instruments.
Yes.
And then the law has to be amended accordingly. However, as I observe that there are certain substantive requirements to be introduced here in order to bring Sri Lankan law on par with the international standard.
Okay, we have only 1 minute more. What is your final advice to anybody who's watching, who's an inventor?
Yeah, excellent. I think first thing is we have to invent, keep inventing. Like in Korea, everybody can invent. We must promote grassroots innovation. As Kumaratunga Munidasa has stated, the nation that does not invent new things would not rise in this world. I would say the world, future. If you want to make the future of the country better, you must promote inventions and innovations, and that is the way. I would definitely want the country to foresee better IP laws.
Right. Dr. Sampath, thank you very much for taking time off and those insightful thoughts. It was very innovative to hear about you, about the patent and the new ideas you wanted to include in Sri Lankan law to develop. Thank you for joining us, and we'll see you another time again back on the show.
Thank you very much for having me and to giving me a chance to tell my findings. Excellent.
You're welcome. And that's Law and Order. You can join the Law and Order conversation on Facebook. That's Facebook/Law and Order Channel I, Facebook/Law and Order Channel I, and you can post your comments and questions there. And we'll join you next week at the same time for